Well, now that we know what prior restraint is, let's take a look at how the courts interpreted it. Our first case is this one, Eyre versus Minnesota from 1929, and it was the case of Jay Eyre, whose scandal sheet published information about Minneapolis officials being in cahoots with gangsters. And under Minnesota state law, he could be prevented from publishing things that were considered to be malicious or scandalous or potentially defamatory. So the question before the court was, does this Minnesota gag law violate the First Amendment? And they decided that it did. What they established was this principle that we still go with that says that the government cannot censor information in advance, even though it may end up being in some way illegal moving forward. So once it's published, it can be considered to have legal ramification, but that doesn't mean that we can prevent it from being published in advance. Now, the granddaddy of all prior restraint cases is this one. It's the New York Times versus the United States. It's better known as the Pentagon Papers case, and it's actually pitted Richard Nixon and the New York Times against one another. Richard Nixon did not want the New York Times and the Washington Post to publish the Pentagon Papers, which was a study of Vietnam that had been leaked by Daniel Ellsberg, and he felt that it was going to be a violation of national security, and we were going to put our troops in harm's way. So the question before the court was this true? Could we validate this idea of national security and authorize prior restraint in that way? And the court in a 6-3 vote said no, that this vague word of security can't be used to compromise the First Amendment. And there was no evidence that publication was going to cause a direct or immediate event that was going to imperil our forces. Now, another case where we're looking at weighing rights against each other, in this Nebraska Press Association versus Stewart case, we had a defendant who was on trial for murder, and the state trial court felt that if the information was released about his confession to police, that was going to compromise his trial. So he put a gag order on the press. Now, when this got before the court, the question was, did this order violate the First and the 14th Amendment? And unanimously, the court said yes, that although there was going to be a great deal of publicity, we could not outweigh the First Amendment in that regard. Now, one thing to come out of this case was what we call the Berger test, established by Chief Justice Berger. He wrote that a restrictive order could be justified where the gravity of evil, discounted by the improbability, justifies this free speech invasion. And so he determined this three-part test, which required intense and pervasive publicity concerning the case would be certain. There was no other way that we could prevent such publicity than a prior restraint, and this restrictive order will actually succeed in protecting the rights of the defendant. Now, another case that we have here is the Landmark Communication versus Virginia case. In this case, the Virginia Pilot published an article about a judicial inquiry and a review commission investigation. There was no question the information was accurately reported. However, there was a Virginia law that said that you couldn't release information from these commission hearings. But Supreme Court reversed the Supreme Court of Virginia in this case and said that the very essence of the First Amendment is to reveal the government in action, and revealing information from this commission was kind of exactly what the press was supposed to do. Now, another case that we're looking at is this West Virginia one, the Smith and versus Daily Mail Publishing. There was a statute in West Virginia in this case that made it a crime for a newspaper to publish the name of a juvenile who had been charged as a juvenile offender. Now, the court found for the newspaper here, and again, we had Chief Justice Berger coming in, saying that the attempts to restrict can seldom satisfy constitutional standards. And as long as the information was lawfully obtained, the state cannot prevent a newspaper from publishing a juvenile's name. Now, in the U.S. versus Progressive case, we had an interesting situation where the Progressive was going to be publishing an article that revealed the secrets of the hydrogen bomb. There's certainly a way that you could argue that that was a national security issue. The judge determined that this publication would have a direct and immediate and irreparable injury to this nation. Now, what ended up happening was another newspaper published this before this case could get all the way through the appellate process. So we're not really sure what the court would have decided in this case, but it's certainly something that we have to consider when we're under these circumstances. And then finally, we have this case, the United States versus Bell. Now, this is an example of, as we talked about a little bit before, that unprotected speech does not enjoy First Amendment protection, obviously, and so circumstances of prior restraint may be different. So in this case, Thurston Paul Bell was publishing ways that you could professionally avoid paying taxes. Now, that is illegal to avoid paying taxes. He invited visitors basically to violate the tax code, and so this idea of protection based on the First Amendment wasn't really available on something that was unprotected speech.